Good morning, everyone. This is Anthony Thorpe again. Yesterday I made I think it was pretty short considering the details, video regarding ownership, mortgages and mortgages that you probably gave to a financial institution when you purchased your home, and the possibly illegality of the whole sales transaction based on a ruling from a Justice Tai from the Supreme Court in 2017, December 12th, 2017, was it? Or November 12th, 2017. In any event, the ruling pretty much made any sales by a developer to any person or contract entered by a developer with any person to develop or purchase property, if that developer did not have a real estate dealer's license, which allows them to do real estate business according to the previous law. And I say previous because the ruling of Justice Tai pretty much changed the law as we were told it represented or interpreted, and was used for from the time the FSC was not the FSC, the Real Estate Board was established. So that ruling changed that law, and it was changed from 2017. So people are wondering, why am I talking about mortgages, corruption in the court, and the relationship? As I said before, I really don't believe in coincidences. When we started our operations, we were victimized, and we've sought relief in the courts, and we're still working at getting that done. But I think it was a matter of judges falling in line with that policy of victimizing persons, that they would go out of their way to come up with judgments that pretty much is right now backfiring, and will continue to backfire on the Jamaican people and the economy. Because here's a judge that made a ruling that just didn't make sense, but essentially punishing us, even though we had legitimate business doing. That was the way of doing business in terms of real estate and joint venture development. So in trying to punish me in particular, even though it was the suit was in a company's name, she ended up instead punishing me, victimizing me, my company, the business, and at the same time now causing major havoc for the economy. But that major havoc for the economy is probably a benefit to, not probably, it's a benefit to every person that purchased a property from a real estate developer that was not holding a real estate dealer's license, pretty much. And that ruling would have been retroactive from the time the law was passed. So that creates a number of issues for the industry. But for you, it the banks have complications because of it. But for the person who was sold those properties, the transaction, the contracts entered were pretty much, according to Justice Tai, an illegal contract. And anything that follows an illegal contract is itself illegal and unenforceable. So I won't go back in all the details, because this insert is merely to clarify and simplify what I was saying to people, because I gave you a lot of details, the background, how we got to that point, and how the judge ended up giving a ruling of that in the context of, again, people in the courts either shouldn't be there or take their responsibilities serious enough to consider the evidence, the facts, and the law, and bring all of those together where they are in harmony to make the right ruling. She completely ignored the law. She completely ignored the facts, ignored the evidence, and even ignored the admission of the defendant, Mrs. King, and made her ruling, which I still can't understand, where she says she agrees with Mrs. King, because Mrs. King agreed that she did sign a joint venture agreement. But that's it. She said the joint venture agreement was illegal, and unenforceable, like any contract, entering any contract, because we're real estate developers and we didn't have a real estate dealer's license. All right, so that's that. Didn't have a real estate dealer's license, and according to her ruling, she changed the law. So simply stated, what I tried to convey to you is that you have certain facts that at your disposal that you could now use with your bank or your lender to state to those lenders or your bank that based on the ruling of Justice Tai, you are not under any obligation to make payments on a loan that was granted or given, used to pay a developer that was selling an illegal product. In short, it was illegal for the developer to sell you that property, and though the bank lent money to buy that property, the bank was also bounded by the law not to engage in financing illegalities in pretty much. So it pretty much for the developer, according to the ruling of Justice Tai, was illegally earned money or money collected on false pretenses. And so even though the bank paid over money to those developers or the parties you purchased the property from, you would be under no obligation to repay that loan, as far as I understand it. But as I said, you could either use the information to try and leverage your loan until a definitive ruling comes out of the appeals court, and then you could decide how to proceed. And in fact, you and your institution can decide how to proceed now, because I'd approach the institution and say to them, well, based on the ruling of Justice Tai, you're not under any obligation to repay this loan, and that ruling would have been retroactive from the time the real estate board was established. But in any event, when she made the ruling in 2017, from December 12, 2017, it would have been effective at least from then. So from 2017 till now, the banks shouldn't have been collecting any money from you for those mortgages, or you shouldn't have been paying that directly to them. But as I said to you, out of an abundance of caution, put your money that you'll be paying to them in an escrow account. Get in touch with them, let them know why you're holding back these funds, and let them either wait on the appeals court or file additional papers for clarification. But as it stands right now, purchasing from a real estate developer, and remember, a real estate developer is not licensed to develop anything or sell anything. A real estate developer is registered as a developer because formerly there was no need for a license, because they're the developers. They own the property, or they're either in a joint venture to develop the property. But these major developers who pretty much have built and sold thousands of homes over the last decade at least, spread across the island, would essentially have been paid money that was illegally collected according to the ruling of Justice Tai. So with that said, again, it's to your advantage, but make sure you take all the necessary precaution to protect yourself. So if indeed the appeals court overturns Justice Tai's ruling, then at least you still have your funds to pay. But notify your banks and tell them why. And as a matter of fact, I gave you the authorization to go pull the ruling of Justice Tai and then have that at your disposal. I gave that information on the previous tape, so you could simply go to the Supreme Court Registry, which is in Montego Bay at Union Street on the NHT building, and ask them for a copy of the Justice Tai's ruling on December 12, 2017, and the claim number I gave, and it would be in the name of Valrine King as the defendant. And and do what you have to do. It's an opportunity for you to make a difference. But essentially, I wanted to show to the world and to Jamaicans that this corruption that exists in the court is not about just collecting money or being paid to do something. It's when judges go out of their way to victimize people they feel are critical of the system and stand up. And the other thing is this a move to stop pro se litigants, ordinary persons, from coming into court to represent themselves? Because in every case that I've been in this court, it seemed like there is a desire or punishment to discourage persons from representing themselves. I remember one judge saying, you need to get an attorney because it's a specialist area. I don't know if the judge realized when she said that what she was saying. She was essentially saying the judicial system is not set up for ordinary people to come in there. Yet the Constitution does state it's for ordinary people to come in there. So if it's such a specialist area, which it shouldn't be, to prevent people from coming there adequately representing themselves, then something is wrong, not with the people coming in there, but the system that they have in place and the rules which prevent people from representing themselves. And I've said before, there are simple ways to clarify or make that happen. But there's this desire, like in the old days of inquisitions, where the church would murder people, no defense. They would have people coming in there and accusing people, and then they would have representations from the crown, but the people wouldn't have, and so those persons end up on the bitter end of the stick. And pretty much, in a democratic country or democratic state in the 21st century, we shouldn't have any system in place that prevents an ordinary person from coming in there and representing themselves. Because it's just a matter of providing the facts, the evidence, the judge assessing the law, and then putting all those together and seeing where justice must fall. It's not a difficult process. So that said, I said this was just a very short insert. One thing you should do if you want to find out if the developer that you purchased your house from had a dealer's license, real estate dealer's license to transact real estate business, simply to call the real estate board and ask them to find out if this particular developer has a real estate dealer's license. And I would inquire not only about those developers, private industry developers that are there doing major developments, like Gore, is it Kankara or one of them, something like that. But I have quite a few. And I'd also inquire about the NHT itself, because the NHT has been selling homes, doing joint venture with other parties and all of that, and providing funding for developers, through partnerships. So does the NHT have a real estate dealer's license to transact real estate business? Because it would also, the law would also qualify them as being in need of such a license. So take the facts that I'm giving you. It's gospel. It's in the records. The law has been passed by Justice J. Tai, TIE, of the Supreme Court in 2017, and it means you have the right to challenge the mortgage you're paying. And as I said, knowing how politics work in these businesses, once they find out that the ruling pretty much favors the homeowner and there's a major advantage, and when you purchase it now and you purchase that property and now you don't have to pay for it, it means that politicians are going to be rushing in there by virtue of pressure from the banks and financial institutions to make a law that changes that. And my estimation is that if a law is made in 2023 remedying the situation created by Justice Tai, then it would not be applicable. It couldn't be redundant, retroactive, to past events. The law would be effective from the date the law is passed. So if the parliament comes in and passes a law in 2023 to remedy what Justice Ty did, then it would mean effectively the mortgages or the payments that you made from the time you purchased your home prior to the ruling of Justice Ty, and during the ruling of Justice Ty to the new law or law that changed it back to what we perceived it to have been, that a developer doesn't need this license, then those funds you paid really shouldn't have been paid over, and they belong to you. But again, that's you now, and everybody getting as many people together do a class action suit, and so that you could ensure that the government doesn't pass laws and randomly force you to pick up payments that legally the judiciary made a law by virtue of Justice Ty's ruling, the Supreme Court of Jamaica, that this is the situation. And your payments would not be due. I mean, if the appeals court does overturn it, then of course, as I said, make sure you have those funds in an escrow account, and I would put it in a financial institutions like the credit union, so you could use that money you're having in there to leverage. All right, so thank you, and you have a good day. As I say, I was short today, so I'd love to discuss a number of other things, but I'm gonna wait to see what happens. But anybody that gets this message, pass it on to other persons paying mortgages, and check it out. If you did purchase from one of these developers, then share it. And the more persons that push this issue, the greater the potential of you benefiting from it. So I'd call my friend and say, are you paying a mortgage, do you? And I'm pretty sure you know other people that's paying an NHT mortgage or a mortgage to a building society, and tell them, listen, we need to check this thing out. All right, so again, in the comment section, send me your comments. I will respond as best I can, but I'm not giving you legal advice or financial advice. I'm telling you what happened to me in terms of the court, the rulings that came down on me as a real estate developer, and what the judge stated, that any kind of agreement that came out of me signing a joint venture or doing a contract where I was not licensed as a real estate dealer for transacting real estate business is an illegal contract, which is unenforceable. So all those joint venture agreements, all of those things that transpired between the developer and the landowner would be an illegal contract, and anything that came out of that would be illegal as well. So I hope it was clearer than it was yesterday, if it wasn't. But essentially, get together with other people that are in a similar situations. This could be an economic windfall for you and those persons, because either way, it puts you guys in a position to negotiate and arrange for better payments or not pay at all. All right, thank you. And one other thing, if indeed the appeals, the parliament comes in and passes laws to remedy this, if they deem it necessary, and you own that home for more than 12 years, it creates two other scenarios. One, the squatters' rights, the limitation act of 12 years, meaning technically you would have be able to own that property because you held it for 12 years, over 12 years, and there was no party who gave you notices to vacate or anything negative in that light. So there is that possibility that you could exercise your constitutional right under the squatters' rights laws for 12 years of occupation, or not occupation, possession. And so you could also defeat them coming back at you if it's a matter of a new law being passed in 2023 or later, or even from the time it was made illegal. So from the time it was made illegal by the ruling of Justice Tai in 2017, that illegality would have existed from the time you enter that agreement. So if you enter that agreement over 12 years to date, when I'm talking or doing this video, it means that there is also that issue that the banks and the developers and will have to deal with. And that means you technically would not or could not be dispossessed of the property if you were in possession of that property for 12 years. Alright, so use the knowledge or use the facts at your disposal, rely on the law, and you might just come out on top. But it means you have to decide, is it worth it? Am I going to save a couple $1 million on this house that I could now put towards my retirement or other investments to generate income to deal with inflationary trends that are bound to happen? Alright, so thank you, have a good one, and talk to you later. Bye.